Okay, so I wanted to talk to you a little bit about abstracts of title. As I wrote above in this blog, title insurance is really the standard today, but every once in a while I come across a seller that says, well, I have an abstract of title. Why do I need to buy title insurance? Well, abstracts of title have really not been used for about 50 years. If someone has an abstract of title for their property, that means they've owned the property since probably the very early 1970s and before. For those that don't know, the abstract of title is a legal-sized document. It looks a little bit like this. Most often it has a blue cover on it. I took it off this one. So you can see it'll say abstract of title, and then the legal description of the property will be typed on the abstract. Inside will be entries showing all of the transfers of the property back to the point that the state of Wisconsin deeded the property to someone. In this case, on this property, goes back to April 27th of 1880. And then every transaction on the property after that was recorded in this abstract of title. You can see sometimes the entries get quite lengthy because every time the legal description is completed. So it took an attorney a long time to put these together. This one is about 75 pages. Some are less, some are far more. So what would happen is someone would get the property, and an attorney, because only the attorneys could do it, would go to the Register of Deeds office, look up the property record, and then make a note of everything that occurred on that property. When it was transferred, who took a mortgage, when the mortgage was satisfied, if someone passed away who owned the property, the probate entry was there. If someone filed a lien against the individuals, it winds up in the abstract. And then the attorney would write what's called a letter of opinion. And he or she would state what they found. They'd give their opinion as to who record title holder was. They'd give their opinion as to what kind of liens might be against the property. They'd give an opinion on if it's a probate, who the heirs are. And that is what people relied on then to transfer property from one person to another. And that was fine. But as I wrote above, you did not have that assurance, that title insurance policy that insured from the date of purchase backward, that if something cropped up, if somebody missed something and something cropped up, that the title insurance company now defends their work. In this case, you had the attorney's opinion, but you didn't have that legal insurance policy behind it. So the other thing I wanted to say is regarding cost, because these documents are so lengthy, because the records have to be looked up and then all entered and then a letter of opinion issued, the time involved in updating an abstract of title and issuing that letter of opinion can be lengthy. And with attorneys charging probably $200, $250, $300 per hour, the cost for the update of an abstract and the opinion isn't going to be much less, if anything less, than the title insurance policy. And again, with the insurance policy, you've got that insurance behind you. So that is why title insurance has become the standard, and we do not rely on abstracts of title any longer.